morning. I think it's about time to start the third session of our conference, or rather workshop, on constitutional protection of minorities, comparing concepts, models, and experiences in Asia and in Europe. We have taken into consideration a number of national case studies on the first session, yesterday in the morning, and then yesterday in the afternoon we went through, I think, a very interesting conceptualization which included sources of international law and included also some special features, or what might be considered to be special features, of protection of groups having their own identity in Asia, and I'm referring here to personal laws as a model of protection of groups having, in particular, a religious identity. Although we also mention the existence of groups that cannot claim to have a religious identity, but perhaps a philosophical identity. Now, I add this just because there has been some discussion on the topic, and because I would say that because of a few countries, but also because of the model adopted by the European Union, I would say that a separate consideration of believers and non-believers is becoming part of the constitutional traditions, if you like, common to the member states. And I'm referring here to the fact that the Treaty of Lisbon, the treaty establishing the European Union, has left the model of relationship between churches and religions and member states unaffected by EU membership, but at the same time has established a model of distinct bilateral contact, periodical and constant contacts between the Commission of the European Union and organized religions on the one hand, and organized philosophical associations on the other hand. I think it's Article 17, if I remember correctly, of the Treaty on the Functioning of the European Union. And I think this because, in a way, we have a sort of, if you allow me, Pamela, we have a sort of no establishment clause. In other words, the European Union as such does not have any preferential ties with any denomination, with any philosophical or Weltanschauung, worldview-based organization, but entertains, not negotiation, but consultations with both, of course, in distinct occasions. Sorry? Dialogue. Oh, yeah, yes, exactly. The word is dialogue. So we took that also into consideration. As I would say, allow me to repeat, I think this may be already considered part of a European model or a European model in the making, although from the point of view of constitutional law of member states, this may be found in Belgium, in the Netherlands, some implicitly in Germany and in other countries, but it is not as clear-cut as in the Treaty of Lisbon. And then, of course, we make reference also to the well-known preamble of the Polish constitution, but the reference is made to believers and those who believe in something else. So I think that is also important because the distinction is not between believers and non-believers, as nobody likes to be defined in a negative, but between believers in one God or believers in something else. So, today, this morning, we are to approach the final comparative considerations, and for this we have two speakers, if I may so, of two speakers that are very well known, internationally well known, as experts in this area, and one might expect that Professor Josef Markov from the University of Graz will speak mainly about the European model, and Alexander Fischer from Jindal Global Law School, New Delhi, or near to New Delhi, will speak about the Asian model. But because they are scholars, I'm sure that they will not resist the temptation of making sort of cross-cutting references, so that each one of them will try to give some sort of at least initial description of what may be regarded the model, if, of course, it is sound to speak of different models when it comes to protection of identity groups. After what I said yesterday, I should not say minorities, although we all know that I mean minorities. Okay, so thank you very much for coming back this morning. May I just introduce also my colleague Jens Wölk from the University of Trento, who will be the discussant for both, and he also, not only he's an expert about rights of minorities, but he's also very, let's say, he's very willing to cooperate. And I would say that accepting the invitation to be the discussant in this final session is absolutely very cooperative. And so I'm personally grateful to him for having accepted this task that he will manage brilliantly as usual. So thank you very much, and I think, Alexander, you're the first to have the floor. Please.
Thank you so much, Professor Tognati, for this wonderful invitation. It's really a fantastic workshop, and yeah, I hope today I can add a few thoughts to the themes that were picked up yesterday already. And the way that I propose to do this is by starting with, I think a good starting point is Wittgenstein. Yeah, it's a comforting starting point. So Ludwig Wittgenstein teaches us that, sort of as a general argument, that concepts do not need clarity for them to have meaning. And this made it much more easy for me to undertake this task, which was quite a mammoth task when you asked me to work on the concept of minorities in Asia. It was very difficult to think about minorities in Asia, and then in addition to that, to bring in this conceptual dimension. One thing that I think came out quite clearly yesterday already is that the idea of this group always will involve some sort of category. That could be race, could be another ethnic marker, could be language. I will also give you some cases today where this relates to health or disability. Yeah? I mean, where these debates are emerging, whether these are minority or identity groups as well. Often it's said that there is popular misassociation between the numerical and statistical dimension of the majority-minority divide. I don't think that's really a misassociation when you look at Asia. I think this question of numbers still plays a crucial role in many of the constitutional conceptualizations of what a minority is. Social power relations definitely are a crucial marker of minority groups, which is the dominant, which is the subordinate groups. That's also clearly there in the case law, quite prominently actually. And I think what has opened up the debate, the concept, is intersectionality across the entire Asian continent, this realization that as the individual you sort of spread out across various groups according to age, religion, gender. And therefore also the concept of the minority in the minority is much more important than it may have been 20 or 30 years ago. My key starting point will be affirmative action. I think that's a marker. I mean, we can compare by looking at the things that are similar. We can compare by looking at the things that are different. I think Asia's commitment to affirmative action and to quotas is, you know, there's a stark contrast to European constitutional intuitions, where we will immediately jump to an equality fear when it comes to affirmative action, positive discrimination, or quotas. Whereas in Asia, from small countries, Sri Lanka, yesterday we heard about Malaysia, Taiwan, Pakistan, but also the two giants, India and China, India has the oldest affirmative action program in the world, China, one of the oldest. These programs affect hundreds of millions of people. And I thought that's a good starting point. Another good starting point is there's a lot of litigation going on when it comes to affirmative action, because there's that cake, which was mentioned yesterday. It's there to grab. So the logic is that you can only get access to this cake if you are part of the minority, if you're the part of this beneficiary group. And therefore, there's a lot of litigations where questions are asked as to what this group is, how is it defined, and who the members of this group are. How do you become a member? How do you maybe lose your membership? The other thing I'm going to look at is language. Europe makes up only 3% of the global linguistic diversity of 7,000 languages. Asia makes up close to 33%, Africa 30%. So there seems to be something else that is fundamentally really different. In my conclusion, sort of the whole theme of this presentation will come together by making an argument that what may matter more than substantive concerns are procedural concerns. I think actually often substantive concerns can stand in the way of minority questions. And I will also conclude that in particular rights questions often can stand in the way because they conceptually narrow minority or group relations, and they might frame group conflicts in a very narrow zero-sum game. So these are some of the concerns, some of the themes that I will be addressing. So coming back to Wittgenstein, you can either call this family resemblance, or I call it a cluster concept, in the sense that there is no fixed core of this concept, and it's strongly associated with other concepts like state, nation, democracy, rights, and equality. So if you do a comparison on the concept of minorities or the theory of minorities between Europe and Asia, you would need to take all these other factors into consideration, in particular citizenship. I think there are lots of differences one could point to towards understandings of citizenship in Asia and Europe, which I think would play an important role for thinking about minorities. I also think minorities are something like, it's a momentum concept. So Hoffman has defined a momentum concept as something that is infinitively progressive. It doesn't have a stopping point. It cannot be realized. So there is, yesterday the word paradox was mentioned in relation to minority rights. Where do you stop when you think about a concept of minority? So you have a minority, within the minority you have a minority, within the minority you have a minority, and then, it's like one of these Russian dolls. So there's a lot of elements in constitutional law that actually sort of start a discourse or a debate that never comes to an end, that just gives us a direction, but not a stopping point. Okay, and I think the other important thing that I learned from the way Professor Tognati gave me the topic is that it's not just about the concept of minority, but it's also about the question of what happens once you constitutionalize such a concept. Because the moment you constitutionalize the concept, all the legal actors out there and political actors, there will be this feedback loop. So you say this is what a minority is, the actors will respond to that. They will frame their documents, their identity, the way they drive policies forward in relationship to the way the Constitution designs what a minority is. And I have a really good example for that from India, where a group first files to become an other backward class, which is sort of a system of group rights, and then realizes that they also could have submitted a claim to become a scheduled tribe, which gives them a lot more rights. So they withdraw the first claim, submit the second claim. And so these sort of things in the procedural side of things, you will see all the time. Okay, so it's just going to be a couple of examples and then sort of reasoning backwards from these examples. What I certainly do not want to do, and it's very important to me to point this out at the beginning, the days comparative constitutional law was done 20, 30 years ago are really over. So that you sort of take a general definition and then you measure other countries towards it and you pick out the anomalies. And so this was a very important book in the 60s, 70s, but today would not just be considered irrelevant, but just wrong and misleading. and look at where India is 20 years after, 40 years after he has written the book, and look at how things have happened in the United States. And this is now what every Indian scholar and student would say with a lot of confidence. Our ideas of minority rights, the way we approach secularism, the way we approach equality, has a lot to do with intra-minority reform and inter-minority management, which is exceptionally complex and complicated, and we don't like to be confronted with a sort of checklist. And they would say, well, this is something that can never happen there, and maybe also picking up your point yesterday in terms of communitarian rights, it's just a different value attached, a different model out there in terms of how far do you take freedom of speech and to what extent do you limit freedom of speech in the interest of minority group protection. So this really would simply be asserted now with a lot of confidence in the context of a global South constitutionalism, and would no longer be considered to be an anomaly. The other thing is a lot of comparative law is actually about intuition. It's not just the concept and the cases and the statutes. It's all the things that surround it. So Pierre Legrand has made this argument very strongly. And this is, again, one of these examples where all of my Indian students fall off their seats when they see this. Because for them, it's actually not conceivable that something like this can become a constitutional amendment. It's really, really out there. So if you encounter examples where you feel, how can this be a minority right or a guarantee, just keep in mind it can also work the other way around that way. Okay, one shortcoming in my paper, I won't be able to talk about, because it hasn't come up in the case law in the constitutions, about the linkages between the internet and minorities. That's very strong in media studies. How is a community formed? How is it maintained? And I think so that's a dimension I'm leaving out, which we couldn't leave out if we do that comparison. So for China, for the Uyghur community, this has already been called in the literature a cyber secession or a cyber separatism. And Arjuna Padrai has used this as sort of a key example for deterritorialization of a minority, which then leads to a re-territorialization of a minority demand. So it's not that territory is becoming insignificant, it's just the way it is, the way we can engage with it is becoming different. And I think it's also fascinating to see how the Chinese state has responded to the Uyghur cyber secessionism with the largest artificial intelligence surveillance program in the world. This is now the most advanced surveillance state, with 20 million new cameras, I think, just in this particular Xinjiang region. So if you ever have time to look at the newspaper articles on that, is really fascinating. Media also, social media and the internet and smartphones, 4 billion people now in the world own a smartphone, communicating with it, forming communities. That also has fundamentally changed the question of minorities within minorities. An example I can give you here is the world-famous Shahbano case from India from the 1980s about the rights of Muslim women to maintenance and the interrelationship between personal law on the one hand side and individual rights on the other hand side. In the 1980s, this entire case and the way it was managed and the legislative debate following that case is dominated by the Muslim Personal Law Board, which is a very conservative, orthodox, Sunni Muslim Personal Law Board. In the recent Shahbano case, it's just a number of women's rights who are amicus in the case, and who are pushing this issue forward. So it's a completely changed landscape, and the Muslim Personal Law Board has been so reduced, in its old form, that their meetings now you have to hand in your mobile phone at the beginning. And we have a PhD student working on this, and all the communication is done in paper because they don't want to come out what their actual views are on these matters. So there's a whole new set of actors, and naturally, when you think about Indian Muslims, you have 172 million people in different parts of the country, speaking different languages, different experience of conversion. Yeah? Many converted very early due to trade in the south. In the north, it's linked to a narrative of conquest and colonialism. Yeah? So all these diversities are being much more addressed nowadays, and I think media, that plays a huge role in that respect. So coming back to the numerical dimension, it's quite interesting to see that the Muslim minority in India is very ineffective despite their large numbers, whereas the Zoroastrian, the Parsi community with just 70,000 left is exceptionally effective. Yeah? Same for the Jain community, which wasn't actually a minority for a long time, so the reason their monks can run around naked is not because they're a minority, it's just regular religious freedom. Yeah, so I think the question of dominance, subordination, numbers, at some point of time you still need to address it when you try to understand these groups and how these groups position themselves within the constitutional system and what they can get out of the constitutional system. Yeah, so Jains and Parsis are able to get the legislation they want. There wasn't a single piece for Muslims in terms of legislation until 1985. Yeah, so for a long period of time, you can really see how they are excluded despite their significant numbers. Okay, so territory and numbers we talked about. Then the next question I wanted to address is sort of moving us to the question of, moving on to affirmative action, Chinese affirmative action, and the Chinese concept of minorities as a top-down driven concept of defining what minorities are. There is just the Chinese state, getting its inspiration from Stalin mostly, but also from a British ethnographer who has written about Chinese minorities. There's a wonderful book on this. And so that's, you cannot find a better top-down definition of what minorities are and how they are identified. So it would have been possible to identify 600, 700, maybe even more minorities. They identified 55 plus Han. So now they have 56 ethnic groups, and that's it. Yeah, that has been stable now for close to 70 years. And I think the interesting thing is, while the definitions have remained stable, the percentages in the population and the census answers have not related stable. Yeah? I think that's very interesting for our concept of minorities. How is your membership in a minority defined? And in this particular case, it's you simply self-identify yourself. So you get a census. If you make a mistake, you have the opportunity to change it, if you can explain why you made the mistake. Otherwise, the way you identify yourself is final for the rest of your life. And very interesting for China, in case of intermarriage, the parents can decide the minority of the kid. Again, this then is final. Yeah? But it's not the state telling you, there's no specific rule about what happens in cases of intermarriage, which is very interesting for India. I think also we can see partly the rise of the minority must be due to the fact that the one-child policy is not applied to them as strictly as to the Han majority. But also I think it simply has to do with, if you want to get into university, you have an incentive to identify yourself as a member of a minority. And the program has been quite successful, from 1.2% university attendance of minorities to close to 8% in the last 70 years. Yeah. Okay, so that's one thing. The other thing that I think we can learn from Asia is we have this sort of memory loss since the Second World War when it comes to ethnic legal categories, racial categories. There's this rich history of Jewish family law and all these questions in German law, for instance. And so, I mean, this forgetting of these categories and how they played a role in the law, it's not that they are forgotten in the sense that you cannot talk about them, yeah, but we no longer have this intuitive sensitivity for these themes. And I think, and of course, we react with a lot of allergy towards it. Yeah? So the problem of denial when it comes to ethnic markers like race or something like caste stems a little bit from the troubled 20th century history that Europe has had. I think that's very different in Asia. And Asia also will share here how these problems of ethno-classification emerge partly out of a colonial context as well. So caste, here you can see a British officer measuring the head. So this is when the British state tries to understand the Indian population on the basis of race. Yeah? This is the last census they do, 1931. Yeah? And before that, they tried other things. They tried religion as a marker for caste. They tried profession as a marker for caste. And it never worked. Yeah? Never worked. Because there is no all-India category for caste. It's a specific local knowledge system that only makes sense in a small locality. So you have the sort of imperialism of categories and vialism towards categories. Once you transplant them, or once you expand them to a larger territory for which they have been meant. Yeah? So it's not just a relationship. Territory not only matters in terms of the numerical, statistical side of things, but also matters in terms of the precision of your category that defines the group. So how can you keep a group together? And is it your incentive to keep the group together, or is it your incentive to split the groups into ever further smaller groups? So that's another conceptual dimension that we can learn very clearly here. There's a wonderful article by Frank de Zwart on the 3 models that you can adopt. Accommodation, the multicultural approach, meaning you engage with ethnic legal markers, with all the problems they will bring along, all the parochial, non-modern elements that they will bring into your wonderful modern legal system. Denial, the ideal typical liberal solution, or replacement in the sense that you look for markers like regional origin or language sometimes, or educational or social backwardness, which is called in India, as markers by which you can actually identify the ethnic group, but you don't have to call it an ethnic group. That's done in France, for the Sorbonne. In France, you're not allowed. It's illegal to keep ethnic records. You can't even collect that data. That would be a crime. But they're trying to understand the diversity by using certain geographies where they know various communities live as a replacement marker. That's also what the University of Texas does after their affirmative action program has been killed. They simply now take students from schools which they know are the minority schools. So they actually have more minority admissions now because that policy, but they no longer talk about ethnicity. They will now talk about geography or working with specific schools. So that would be replacement categories. In India, in contrast to China, the entire process of minority politics is bottom-up. It's not top-down. And if you are a democracy, that has certain consequences, and the number of minority groups has sort of spiraled out of, I don't want to say out of control, but we are sort of in a situation in which we have a majority of minority groups, simply because these groups have learned to articulate their identity and to place themselves in their relationship to the Indian state as a minority group. Why? Because there are all these benefits deriving from that. Educational benefits, access to universities, but you can also run your own minority institution, which gives you a number of grant possibilities. You can apply for state aid. So there's a whole public choice economy, you could say, set up that furthers the creation of new minority groups. So you can see, if you add all the minority groups together for Tamil Nadu that have been identified by the state, you come close to 100%. There's just a very small section of general citizens left who are not members of a specific group. The same is true for states like Chhattisgarh or Jharkhand with a very strong Aboriginal population. And actually only minority of Indian states now has a population where the minority groups make up less than half of the population. So you can see, you can simply see when you let these systems run wild, where you end up. Okay. The other consequence I think you have here, this complexity, once you let these minority groups play with each other, you let them sort of out of the bag, they will intermarry, they will convert to different religions, they will excommunicate members. Yeah, and for all of this, you need legal answers, because all of this will be case law. So if you have an affirmative action system where you're only allowed to stand for a specific constituency when it comes to elections, you're only allowed if you are a member of a scheduled tribe, the courts will have to decide whether you actually are a member of the scheduled tribe. Yeah? What if your parents have converted and you have reconverted? What if you were adopted? Yeah? So all these things will come into the case law. And all these things will give us a better understanding of what are the markers with which we conceptualize what this minority group is or what this identity group is. Case law in India is very chaotic because they have so many small benches and so many courts. Yeah, so Krishna I has called it a conceptual disaster area. But there's still some stuff we can learn from this. Intermarriage is not strong in India yet between castes and religion. I think it's less than 10% still. So you will still identify yourself, when you're searching for a marriage partner in an online portal or something on the basis of your caste and religion. The Indian state actually tries to encourage intercaste marriage. I think that's interesting. You get almost 2,500 euros, which in India is a princely sum for an intercaste marriage. This used to be state level based. It now is a central scheme as well. Last year, 15 couples registered for that in a country with 1.3 billion, and this year, 67. 15, 1.5. Yeah, because there's very little knowledge of the law on the one hand side, but it also gives you an impression of attitudes towards intercaste and interreligious marriage. It's still quite strong. It's different in cities. That was another point I tried to research for this paper. The mega cities in Asia, 35 million people living together, 30 million people living together. By 2050, all the world's biggest cities will be in Asia. That's going to lead to a certain new style of cosmopolitanism, I think, which will have an impact on minority politics as well. Then there are those groups in India which actually are brand new. So this is a new group called the Neo-Buddhists. So then the question is, can you constitutionalize your own new minority group out of the blue? How would you do that? And there's lots of case law on the recognition of their marriages, because they are rejecting all Sanskritic religious elements in their marriage rituals. And in Tamil Nadu, there's a similar style of this marriage called the self-respecter marriage, which has been recognized by legislative act. But the courts for Maharashtra, there is no such legislation, and to this day they struggle to recognize these marriages, which is quite remarkable, because these Neo-Buddhists, the first Neo-Buddhist is Dr. Ambedkar, who's the founding father of the Indian Constitution. And so he converted in 1956 with 300,000 people, and ever since it's a specific new form of Buddhism. And you can see how difficult it is to establish a category that's new if it doesn't have this ancient marker, ancient custom marker that so many other Indian religions would have. Okay, all right, I think I'll jump over this. I know, maybe I should mention this. Another element which we must keep in mind is, I think, the purpose of minority protection. Is it assimilation? Is it group equality? What actually is the outcome that we want to achieve when we manage the relationship between different minority groups? In India, for a long period of time, when it came to caste, the idea was that caste would disappear. That was the vision in the 1950s, 60s. That vision has completely disappeared. The Chief Justice of India, in a famous case in 2008, has said that has failed. And so now what they're trying to do is to make sure that there is no discrimination between the caste groups. So it's a new goal, establishing the equality between these different identity groups, but no longer the abolition of the group identity itself. So the group identity survives, just the rules with which groups interact and how they view each other that has to change in a sense of abolition of untouchability, or in a sense, in the sense of ending discrimination. And then I thought, before I move on, I'll just show you how this works in practice, because all this case law is creating an enormous complexity, which brings us another question, I think, in relation to the concept of minorities, is how many groups you actually can manage. Yeah? Can you manage 100? Can you manage 1,000? Can you manage 18,000? Can you manage 20,000 different groups within the same constitutional legal system? How complex does it get? Especially when you take into account intersectionality. So affirmative action in India now works on the basis of caste, tribe, other backward class, but also on the basis of gender, disability, the region, your educational background. All these factors are being taken into account when it comes to assessing your ranking in this positive discrimination theme. And so it's getting very, very complicated. So for instance, let's assume you have a female scheduled caste candidate. Would she now fall into the female quota or into the scheduled caste quota? Yeah, all these questions are coming up. There's a huge bureaucracy surrounding this. Everybody needs a caste certificate if you want to apply for these special posts. The system of caste certificates is very unstable, should we say. There are 35 million false ones. So now they have a system of validifying their caste certificates. Yeah? And here we come to the interesting point, which I think for the conceptualization of minority groups, the question of the groups within the groups. So India has invented here the system of creamy layer, in the sense that if you have a group that is subordinated, there will be people within that group who actually are not subordinated, maybe because they're very rich, or maybe they live a very privileged lifestyle in an urban area. So they will first identify you as a member of the group, but then in the next step, you now need a second thing. You need a non-creamy layer certificate. So they call this the creamy layer. When you make butter, cream rises. And so this is a judicial doctrine that has been very successful, a big policy success. Is sort of the only thing the judiciary has contributed to this that has stuck. And so there are now certain criteria to split you up into various groups. Now, the other question is whether you can take this subclassification further. So there is, for instance, in the state of Andhra Pradesh, there are 2 scheduled caste groups. One of them is very small, the Malas, is just about 100,000. And the huge scheduled caste group, close to 5 million, is the Madigas. But they're both in this big category scheduled caste. So the question was, how can you distribute all the benefits in these policies? Can you have a subclassification within groups? And the Indian Supreme Court has just stepped in and has said no. There's a very weak jurisprudential argument for this. It's essentially a policy decision that we do not want to have further splinter groups. It's the same way the Indian Supreme Court treats religious minorities. When there is a sect demanding, I'm actually just a sub-school of this particular religious minority, the Indian Supreme Court will almost always go against it. So there are actually very few religious minorities in India. It's just Hindu, Muslim, Buddhist, Sikh and Jain, and Christian. The rest has not been officially recognized yet. Now you could, of course, imagine, and there's lots of case law on this, Ramakrishna Mission, the Lingayats, a lot of these groups have gone to the court and have argued we actually are minority groups. And here the concept is held in place not in terms of empirical, the decision of the courts, you can't ground them in empirical or historical analysis. It's just a policy decision that the court is making that too many minorities would be detrimental to managing the system of group rights. Some new groups make it to the front. Transgender has been recognized as a minority group in India. That's purely case law based. Doesn't come out of the parliamentary process, but has been picked up by parliaments very strongly. So in India, we have 25% of places in schools, even private schools, are reserved for kids from a poor, backward. India uses this terrible term, backward. So these are the backward groups that have special reservation in these schools. So the transgender minority has been recognized. And also health has been recognized in relation to HIV as a minority group for which you can have a specific legal category. Okay, time-wise, how am I doing? Another 5 minutes maybe?
In fact, I forgot to check that when
Yeah?
you started to talk, but shall we say 5 more minutes?
Yeah,
Is that
okay.
all right?
Yeah.
Or why don't you take 10, then we have a coffee break, and then, so you have longer time without.
Is that okay? Everybody still with me, or have I? Not everybody, I'm assuming.
We are
Some.
all, yes.
Okay, I'll come back quickly to Professor Amirante's point yesterday, not because I want to talk about language politics, but because I want to talk about the regulation of territory, how we imagine territory, and how it relates to the concept of group rights. You can imagine, that's why, they have this wonderful map where India is sort of turned upside down, which should inspire us to be creative in thinking, how do we link territory to systems of governance, to different models of citizenship, to different group rights. And there are all these ideas out there. And I think yesterday, we often talked about this in terms of institutional design. I have a problem with the term design because there were a lot of actors in this which simply died at the wrong point of time or too early. So Jinnah, he actually was very sick when he kept pushing for the division of the subcontinent. So the creation of Pakistan, you might argue, if his tuberculosis had struck earlier, might have never happened. It was not a question of constitutional design. Am I freaking you out? No? Same for Subhash Chandra Bose, who was in Nazi Germany a long time. Then they took him by submarine to Japan. He tried to come back to India and bring fascism to South Asia. He died in a plane crash, so that never happened. Otherwise, the Indian National Army was quite a force to be reckoned with from Bengal. And Gandhi's interesting constitutional visions disappear due to his death, and in particular the disappearance of Subhash Chandra Bose, who was sort of a Bismarckian figure, very authoritarian, has had a huge impact. So the reason why we have ended up with the system as it is and why it developed in a specific sense is partly design, partly fortuitous. But we can see one trend. It's always politics from below. So again, I wanted to push the point that Professor Amirante made yesterday. The articulation of what a minority is and the demand for minority rights were a bottom-up process. So this is actually the politician who has fasted himself to death and then triggered a political crisis, which has led to the entire redesign of the Indian map. And this was beautifully described yesterday. I just can show you the map because I have it anyway. So this is the British legacy. This is just a set of historical accidents. Where was the army successful? Where were they able to co-opt a local leader? There's no rationality behind these boundaries here. And in that sense, there's also no particular rationality in the sense the British Empire governed these minority groups or established a system of groups. And here you can clearly see there is no majority language. Hindi is just 30% in the 1940s. And all these various languages that were discussed yesterday are in the 2 or 3% category. And now you see the shift in territory. The map is redesigned in relation to linguistic communities. And then another redesign in 72. There's this pattern which was discussed yesterday. And now you can see how the minorities have become the majorities. So I think in terms of conceptualizing, we cannot too quickly get away from the nexus between numerical dimension statistics and territory as well. We just have to be aware how quickly all of this can shift. Okay, so what is this overall theme that I have picked up? So much has gone really well in Asia when it comes to minority conflicts, not everything. There's also, and one of the things that hasn't gone well is the role of the cow yesterday. So you didn't tell us enough of that, Mara, so I thought I'd bring it up today. And there's a wonderful book by Hannah Y. Is that in your series, in the Brill series, on a dialogue approach to minority rights. It's 2016, a Chinese scholar. Very interesting chapter. So the chapter, I haven't been able to get the entire book, but I saw parts of it. So I was particularly intrigued by the chapter on the rights of the majority against the minority. That I felt was very interesting, plays a little bit into the duties theme we have discussed yesterday. But also she says we need to find models of dialogue that are non-legal. Yeah, especially that get away from a language of rights. And I think here's a great, sorry, it's the wrong slide. There's a great missed opportunity here in the Constituent Assembly. So in India, they never have the guts in the 50s or 60s to say the cow is holy or the cow is an important animal to the belief systems of many people in our country and we will protect it. Yeah? Because they thought this would undermine the secular nature of the Indian constitution. So they have this weird Article 48 that says in order to maximize milk production in India, you cannot slaughter cows. Yeah? And all the early case law is just about how many cows there are, how many goats there are, what happens to the overall population, what happens to their milk output. This word religion doesn't disappear. Yeah? The Supreme Court pushes this aside with a few sentences. Cow sacrifice of Muslims is non-essential religious practice, so end of story here. And it's all discussed in terms of freedom of profession. Is a butcher or a Muslim butcher allowed to slaughter a cow? So they take this totally out, but in the Constituent Assembly, those who want the cow protection, they say, why can't we say clearly and frankly with a little bit of, a couple of plain words that we want this to happen? And also the Muslim representatives are saying we have absolutely no problem with that because they don't eat such a lot amount of beef, it's more mutton and other animals. And they say if the majority expresses itself clearly and definitely, then we know exactly what the position is. Yeah. And this has never happened and is still being discussed in the language of conflicting fundamental rights. So Hannah Weiss writes, the root of all evil are unstable, generalizing conceptual tools. As this book has aimed to show, it is both necessary and possible to reconceptualize minority rights by making it less substantive and more procedural. Yeah? Focusing on building dialogical procedures and particularities and so sort of take it out of the courtroom and maybe out of the legislative process. And she discusses this with respect to the French burqa ban, where she says, if you immediately start off by saying, oh, this is a religious right, yes or no, you sort of raise it to a level that was entirely unproductive to both sides of the argument. And I think, when looking for examples, I think there's a very strong trend that I saw when it comes to the constitutionalization of minority rights. And there is a different story in the language politics. The reason why Indian language politics was successful is because they deconstitutionalized it. They took it out of the constitution into state legislation, and they postponed a lot. Yeah? So they said, okay, we're not going to think about a national language for 15 years. So they actually transformed this entire conflict by taking it out of the constitutional realm and out of the rights realm to some extent. Yeah? Okay. I think that's my conclusion then.
Thank you very much. In fact, if we look at the slides that you are showing us today, we see that there is nothing so far away from the concept of a colorblind constitution. Look at all the brightness of the colors that, and this corresponds very much to the setting of India and many other countries that you have so brilliantly described. So thank you very much indeed. We know much more now than we did half an hour ago. So because it is already 10:30 almost, I suggest that we take 10 minutes break, have a coffee and perhaps a sweet or some fruit or whatever is available, and then we come back and then Josef Marco will have the floor. So 10 to 12 minutes. All right, so I think it is time to start again our session, and the floor is to Professor Josef Marco.
Thank you so much, Roberto. And again, I'm so happy to be here and be able to participate in this conference, and also have now an opportunity to present tour d'horizon, or even tour de force, through European history and the constitutional problems we face over the last couple of centuries with regard to minority protection. I will start immediately with two examples from case law, just to give you a flavor what might be the problem with minority protection in Europe until the very day. Here you can see a quote, several paragraphs of the reasoning of the Advocate General Juliane Kokot in the case Adspieter versus G4C Secure Solutions in Belgium before the European Court of Justice. And the case is about horizontal effect of freedom of religion, because Mrs. Adspieter wanted to wear the headscarf in the workplace, and the company, G4C Secure Solutions, had a company rule asking all the employees of the company to stick to strict neutrality, not only in religious terms, but also what you are very interested in, philosophical terms and ideological terms. And what you can see here is not, I would say, the traditional legal reasoning in a judgment, where you start again with what is the meaning of discrimination, anti-discrimination, and freedom of religion. But you see here, first of all, quotations from the introductory part of her opinion, where she tries what we now call in postmodern sociology the framing of the case. And I highlight in red how she frames the overall problem to be solved by the European Court of Justice. So again, to remind you, traditional lawyer would start with definitions, which was mentioned before the coffee break by Mr. Fischer, and then say what are the legal sources in the EU law, in particular the race discrimination directives with regard to direct and indirect discrimination, and how can you then apply the rules following from these definitions to the case? No, she has a different starting point here. And paragraph 2 of this introductory part reads, there is no need to highlight here the social sensitivity inherent in this issue of horizontal effect of human rights, particularly in the current political and social context in which Europe is confronted with an arguable, unprecedented influx of third country migrants, and the question of how best to integrate persons from a migrant background as a subject of intense debate in all quarters. And the quotation goes on, ultimately the legal issues surrounding the Islamic headscarf are symbolic of the more fundamental question of how much difference and diversity an open and pluralistic European society must tolerate within its borders, and conversely how much assimilation it permitted to require from certain minorities. And again, I want to highlight the mode of framing and using concepts you are already familiar with. Integration, assimilation, tolerance, what else? And more to the point of the case, then she argues it must be borne in mind, after all, that the company rule requiring strict neutrality, as that operated by the company, is not limited to a ban on the wearing of visible signs, well, or wearing of visible signs of religious beliefs in general, but one and at the same time also explicitly prohibits the wearing of visible signs of political or philosophical beliefs. And the company rule is therefore neutral from the point of view of religion or ideology. And finally, which is really the final point I want to make here with regard to conceptualization of the terminology she uses, which might be a little bit provocative, again for religious believers. However, unlike, this is her argument, not my position, of course, however, unlike sex, skin color, ethnic origin, and so on, religion is not so much an unalterable fact, the other way around, sex, skin color, ethnic origin is your biological trait, as an aspect of an individual's private life. So religion is private. This is the message given here. And moreover, over which employees concerned can choose to exert an influence. Because you cannot change your sex, you cannot change your skin color, is almost the underlying the message. So when or while an employee cannot leave his sex, skin color, ethnicity, and so on at the door, in the German original, es an der Garderobe abgeben, which is the German original, entering his, so the German is much more offensive than the English translation. Upon entering his employer's premises, he may be expected to moderate the exercise of his religion and behavior and his clothing. So, what is religion all about? Is it a public affair? Is it a human right? Is it simply a private feeling? So, how do you conceptualize religion here? That's the big question. I do not go on to comment this, because this is, of course, the overall task of my presentation here, to come basically also to a critical ideological analysis of case law. But give you a second example, the famous or infamous case of the Peuple Corse decision of the French Conseil Constitutionnel, when the Assembly of Corsica, the island, adopted a bill in 1991 in the framework of a draft autonomy statute, and ruled out in Article 1 of the draft autonomy statute that the French Republic guarantees to the historic and cultural community which constitutes the people of Corsica as part of the French people the right to preserve her cultural identity and so on and so forth. So again, highlighted in red, the notion that there is a French people, but at the same time also a Corsican people, which forms part of the overall French people. And how do you guess that the Conseil Constitutionnel will have decided the case? Article 2 speaks about the of the French Constitution, of course, speaks about the indivisibility of the Republic and the equality of citizens before the law, without distinction of origin, race, or religion. And Article 3 declares that national sovereignty belongs to the French people, so that no section of the people nor any individual may abrogate to themselves or to him or himself the exercise thereof. Now, and if you interpret these two articles in a very literal way, you come to the conclusion that there is only one French people, indivisibility, one French people. You cannot have a Corsican people, full stop. So this was this phrase that the Corsican people is not a separate people as such, claiming self-determination, independence, or what else, but is anyhow a part of the French people, was declared unconstitutional. So again, we have to ask ourselves, what is the role of concepts, not only terminology, but constitutional concepts? Where do these ideas and concepts come from, and that therefore I think it is absolutely necessary to go back into European history and to see what are the basic trends in the development of state formation and nation building in Europe in order to overcome the generalizations we have been using all the time of a Western legal tradition, of European values, of as if Europe would be a homogeneous space or culture. And in the end, of course, what we have to face here is the basic problem and the question I want to raise from scratch. If, as you can see, from the headscarf or from a notion of a Corsican people, is the question whether all minorities, be they national, so-called national, traditional, autochthonous minorities, or indigenous peoples, or new minorities stemming from immigration, always a danger for political unity, social cohesion, or even physical security, because the phrase the Balkanization of Europe can be found in many treatises on history, but also political sciences, sociology, and law. So the overall question is, why shall we protect minorities at all? If, and now comes the point, what we discussed already yesterday with regard to modernization and modernization theories, why should we protect pre-modern lifestyles, tribal communities who do not guarantee the individual human rights of their members by definition, but have different practices and even make claim in terms of legal pluralism and personal laws of religious communities maybe, to have an exemption from the overall civil code, what else? Our second question, are the rights for collectivities, again, here on the quotation marks, the groups, not by definition an aberration from the very Enlightenment history and philosophy and development that human rights are first and above all the individual human rights which have to be protected. And thirdly, is minority protection not an anti-liberal conservative ideology of culturalism against all these developments over the last couple of centuries, leading to modernization, in short, secularization and individualization by the development to industrial societies, post-industrial societies, what else? And the second question, nevertheless, if we should protect, if we find arguments why we should protect minorities, then the next question is it possible to effectively protect them and to foster plural diversities within the framing, the philosophical or ideological framing of the European nation state and its underlying ideologies of liberalism and nationalism? So this is the overall task I see to explain in a nutshell in the next 10 minutes to you what is going wrong with minority protection over the last 400 centuries in Europe. I skip my methodological observations and come back to territory and maps. So this maps shows you the geographic composition of Europe before the Berlin Congress in 1878. And historians like the German historian Theodor Schieder, but also Ernest Gellner from London School of Economics, came to an overall structural model of the development of state formation and nation building by distinguishing three areas and three phases of state formation and nation building in Europe. First, the first phase and the first territory is Western Europe, where territorially concentrated central states were established before language nationalism became a dominant ideology in Europe in the middle and end of the 19th century. Secondly, you have Central Europe with a plethora of tiny little states, city-states, but also little principalities and, of course, larger kingdoms like Prussia or Bavaria, so that there is no Germany, no Italy until the middle of the 19th century. Don't forget, and only in the middle of the 19th century we have the unification of Germany and Italy into nation states. And thirdly, as you can see, going further east to Eastern and Southeastern Europe, you have the legacy of three multi-ethnic empires: the Russian Empire, the Ottoman Empire, and the Habsburg Empire. And the collapse of these three empires after World War I again marks a shift to a new formation of new states. So what you see here is already a map from the beginning of the 1990s, so 1993, 1994, where you can see that also in Eastern and Southeastern Europe, the nationality problem and the fragmentation based on the nationality problem of territory goes on. So you have no longer Czechoslovakia as a binational state, but the separation into the Czech and Slovak republics. You have the breakdown of Yugoslavia into several new states, and you see here Kosovo is not yet recognized here as a new independent state, and so on and so forth. So this is what we call this matryoshka or Russian doll, principle of territorial fragmentation following from language nationalism. And finally, the last map, which you can see here, that against all ideological concepts of an identity of territory, culture, language, you see here until the very day the borderlines of the political borderlines and the linguistic borderlines do not yet overlap until the very day. So you have this in orange colored areas where you see these are linguistic minorities within nation states in Europe. So just a reminder, as a starting point, the breakdown of the medieval identity of religion and politics through the Protestant Reformation and the religious wars in Western and Central Europe, in particular with the end of the 30 Years' Wars in the 17th century, and the treaties of Osnabrück and Münster, so this is the Westphalian peace system, established what we call today the modern legitimation problem. Why do we need to legitimize the exercise of political power, of physical force? This is not a medieval problem at all. This is created by the Protestant Reformation and the civil wars. How is it possible to stop civil war and to create peace and security? And how can you legitimize, therefore, an institution or even a person who has the task to secure peace on the ground? So this is the sovereignty concept, as you all know, starting with Jean Baudin's Si libre de la République and the conceptualization of this indivisibility of sovereignty as a necessary conceptual notion in order to arrange for peace and security on the ground. But again, the question is whose sovereignty? Is it, well, who is the sovereign? Is it the monarch, the absolute monarch, the state as a more abstract construction and notion? Is it a nation, or is it the people who are sovereign, if you remember the Bebercour's decision of the French Conseil Constitutionnel? And you see the traveling, the migration of the concept of sovereignty through all of these concepts and notions, from the monarch via the more abstract concept of the state to nations and people, again with the question, how are we going to understand the meaning of a concept like nation and people? And I will come back to that in a moment. But before, what we can see in 300 years of European history are three models how to secure peace on the ground. The first was established already with the Augsburg religious peace settlement in 1555, with the Latin phrase cuius regio eius religio. So the king, the prince, determines the religion of his subjects, full stop. And who does not want to belong to this religion has not a right, but is allowed to emigrate. He will not be forced to conversion any longer, or he will be killed. There is no ethnic cleansing by definition in the modern terminology, but you will be allowed in some way to emigrate. And as you can see, again, this model can be transposed also into language, so that we can ask ourselves, now is the new formula created in the 19th and 20th century, cuius regio eius lingua. And Switzerland, Belgium, but also Bosnia-Herzegovina could give us example to think about the question, do we need linguistic homogeneity by definition for the conceptualization of a multinational state, but nevertheless a multinational state to be based on the linguistic homogeneity of its constituent units, like this is the case in Belgium and in some way also in Bosnia-Herzegovina. And as far as the external relations are concerned, this is a short reminder only. This is, of course, the beginning of public international law. And you have a lot of treaties in the 17th and even beginning of the 18th century between the newly created territories and states where what we today would call religious minorities, in particular Catholic religious minorities, then are guaranteed freedom of religion within countries with Protestant majority populations, basically. Second phase and second model with regard to peace and conflict regulation are the political revolutions, as a reminder, here England, the US, and France. What we have in the end is the idea of a separation between state and churches, no longer to allow for established churches. And therefore, the question is raised, shall we have also a model for conflict regulation in terms of a separation of state and ethnicity? Colorblind constitution was already mentioned this morning. France with the laïcité principle. But again, this model was also introduced in the Turkish constitution when Atatürk established the modern Turkish Republic, and you will find it also even today in the Bulgarian constitution, for instance, prohibiting the establishment of political parties along ethnic lines. This is a constitutional doctrine. The practice is, of course, a little bit different. So, again, models. And my basic message here is we have two completely different opposing models of nation states in Europe. There is not the nation state, the European nation state, but we have two each other opposing models. how to combine the two basic concepts of state and nation. And yesterday, the concept of state-nation with regard to India was already used, yeah, and it's completely different. Yeah? As you can see here, what I call the French civic state-nation model, based on the constitutional principles of the cultural indifference or state neutrality, not only vis-a-vis religions. Yeah, you are not, as was mentioned this morning already by my colleague Fischer, yeah, with regard to affirmative action. Yeah, there is affirmative action in France, yes, but you are never allowed to name a targeted group. Yeah, it's on a geographic, territorial basis that you use affirmative action instruments. Second basic principle, strict individual equality before the law. Laicité was already mentioned, and which is so important for the Peuple Corse decision, is the concept not only of popular sovereignty as a principle for the democratic for the legitimation of democratic state organization, but in addition to that, the concept of national sovereignty, so that the concept was developed in the migration of sovereignty, that also the nation is sovereign in the meaning you can have only an indivisible nation. There is only one nation and you can have no other gods beside you. There is no multinationalism possible. One God. Yeah? So this is the theological maybe background of the concept of sovereignty. Anyhow, what are the empirical consequences? Anti-pluralism, no federalism possible. The Loi Chapelier already at the end of the 18th century prohibited the establishment of trade unions. So no pouvoir intermédiaire, as this is called in French, allowed according to French constitutional law. And the empirical consequences, in the end, you're supposed to assimilate into a civilisation française. The exactly opposite model is the German ethnic nation-state model. And I do not go back into the history of philosophers, Johann Gottfried Herder, Hegel, Schleiermacher, and all these guys developed the idea that you have one language, the German language, which is the marker for the definition of what the meaning is of one German people, and every people has a right to establish its own nation state. So the principle of national self-determination created in philosophy by the end of the 18th century in German philosophy. What does that mean? As a consequence of this Trinitarian conceptualization of language means by definition that you have one collective identity and you are only a member of this community, that cultural diversities are categorically redefined into ethnic difference between a majority and a minority. The French state-nation model does not recognize a differentiation between majority and minority. This is not part of constitutional doctrine in France. There are no minorities in France. Therefore, France made a reservation with regard to Article 27 of the International Covenant of Civil and Political Rights. So we have no minorities, therefore this Article 27 cannot be applied in France, full stop. And this reservation is still in place until the very day. And finally, with regard to the German model, again, equality is no longer a equality between human persons in terms of equality between human individuals and human rights, but equality is reduced to the members of, within the same group. Others might and will be treated differently. And what does that mean in the end? Of course, in legal discourse and legal conceptualization with regard to formal equality, substantive equality, was already hinted at this morning with regard to affirmative action. We'll come back to that, of course, again. but I have, I have to jump up. So the empirical consequences of this model is genocide, ethnic cleansing, institutional segregation, and racial discrimination. So this is basically the dark side of European history of state formation and nation building, and not only the positive bright side of Enlightenment philosophy and rationalism and French Revolution as a universal model. So I skip more or less the history of the 20th century again, after World War I, with Wilson and Lenin further conceptualizing the concept of self-determination. We have the legal framework of protection of minorities and the League of Nations. And what is very interesting already, the establishment of a concept of territorial autonomy for the Åland Islands in 1920-1921. And I could come back to that, of course, in the discussion. And after World War I, we heard yesterday from Francesco Palermo already, basically no longer group rights, no longer any ideas of collective protection mechanisms, but everything is individual human rights and anti-discrimination. You have it at the UN level with all these covenants quoted here, but in particular also with the European Convention on Human Rights and Article 14 as the anti-discrimination provision in the European Convention on Human Rights. After 1989, again, Francesco Palermo has talked extensively on this yesterday, the OSCE High Commission on National Minorities as a conflict prevention tool, and the Council of Europe treaties for minority protection. There is not only the Framework Convention, but also there is a European Charter for Regional and Minority Languages, however, ratified only by around 24 members of the Council of Europe, whereas the Framework Convention is ratified by 40 members of the Council of Europe. What are the most recent trends and developments after 9/11 in Europe? Is there now a swing back of the pendulum, of what I call here a renationalization of Europe? And again, you see the doctrine of the three phases and the three areas popping up again. We have violent conflict and war with the breakdown of the communist federal systems, Yugoslavia and the Soviet Union, until the very day the war, the hidden war, undeclared war in the Ukraine. And the basic question is, are these wars ethnic conflicts? Are ethnic conflicts the root cause of these wars? Therefore, a question mark. In Western Europe, the national paradox with the independence movements in Scotland, Catalonia, and Flanders. Again, the question is this a breakup of the historic development, so that the United Kingdom will again be disaggregated into its component units? And again, for Belgium, will it again disaggregated into the two basic component units? And all over Europe, immigrant integration, the so-called backlash of multiculturalism and Islamophobia on the rise, with what you can see in particular with the electoral victories of right-wing populist and even right-wing extremist parties all over Europe. The key themes and topics used in this multicultural backlash can be again summarized with here in these 3 points. Following Huntington's infamous book title, The Clash of Civilizations, there is now the notion of a clash of cultures, in particular again the West versus Islam, with the underlying notion that Muslims cannot be integrated by definition. Ethnic diversity is seen in residential segregation and the unwillingness of to assimilate, of immigrants to assimilate. And thirdly, what you also see from statistical evidence, the socioeconomic positions of immigrants is much worse than that of the majority population, high unemployment rates, so-called dependence on welfare subsidies, and juvenile delinquency. So the conclusions and consequences which we have in public political discourses all over Europe, not the least in Germany and Austria, we have to protect the values of the majority against all these illiberal cultural practices brought with them by the immigrants. Official languages have to be protected, in particular in the nationalisms of the Baltic states, for instance, with the huge Russian minorities. It's again the case law of the Supreme Courts and constitutional courts in the Baltic countries. They say, no, we have to protect not the minority languages, bracket Russian, but it's exactly the other way around. We must protect the official language against all these minority claims. And, of course, Austrian values, European values are brought up now in the public discourse to be protected so that immigrants do not have to integrate, but to assimilate. So this is the neo-assimilationist trend in public discourse, but also in sociological literature. Our colleague Jobke, for instance, is very basically arguing along these lines. So, to come to an end, instead of the German-French opposing models, Tognatti, Palermo, and Wölk have a more sophisticated differentiation in their scholarship so that we can distinguish between the repressive regimes, liberal regimes, so-called promotional regimes, and multinational regimes. And for me, the question is, are these models and concepts, underlying concepts, really an analytical framework and tool in order to understand what is going on, not only in public discourse, but also in the reasoning of the judgments, as I tried to demonstrate with Advocate General Kokot's reasoning with the ban of the headscarf in a private company, or the Purple Cross decision. So again, what is the role of ideologies? And I come, therefore, to my basic hypothesis. We need to deconstruct of what I call the monist identitarian nation-cum-state paradigm, always presenting minorities as a danger. And this monist identitarian nation-cum-state paradigm, and thereby I follow your structural approach, as you can see, is based on the epistemological level, on essentializations and the naturalization of social constructions and legal categories, exactly what Kokot did when she declared that sex, gender, ethnicity are natural categories, which are unalterable, in contrast to religion. And what we discussed already yesterday all the time, we have all these dichotomies, public, private, politics versus culture, individual rights versus group rights, and in the end, the civic and ethnic divide. And my argument is, forget the civic ethnic divide. What you have with regard to the civic ethnic divide is only a choice between two evils, either to assimilate or to be driven out of the territory, to be killed, or to be segregated. Is this the only choice minorities have in Europe following these two different models? Is there no way in between this killer of assimilation and the Charybdis of all forms of separation? So it is necessary to deconstruct our ideologically informed conceptualizations. Therefore, my argument, liberalism is not liberalism. You have to distinguish at least between three forms of liberalism, what I call the libertarian individualistic liberalism, paternalistic liberalism, or communitarian liberalism. I will come back to that, just to give you an idea that liberalism is not liberalism. And secondly, what are the conundrums of the liberal democratic form of governance? And you can identify, with regard to all the failed efforts of minority protection in the dark side of European history, along these 3 points, bullet points. The majority principle is connected with the myth of ethnic neutrality. Secondly, the distinction between formal and substantive equality is again trapped in what Martamino calls the dilemma of difference. Therefore, I argue we have to develop a third concept, which I call institutional equality. And finally, sovereignty or autonomy. What concept of self-determination do we have in the end? National self-determination based on the model of the Westphalian doctrine of sovereignty, or political self-determination based on a reconceptualization of autonomy as what is called in British history of ideas the distinction between positive and negative freedom. So negative freedom means you can do whatever you want, yeah? To freedom from non-interference into your affairs. Or positive freedom means we are all interconnected as human beings, and therefore my freedom ends where your freedom begins. So this is the concept of autonomy in my eyes and in terms of positive freedom. And of course these completely different conceptualizations of freedom, of course, inform, therefore, also the constitutional principles of national versus political self-determination. I skip again, for the reasons of time, an overview on the basic ideological distinctions in terms of naturalization of difference in the form of racisms, the classic traditional form of racism going back to the 19th century, and what is called now the differentialist racisms of the right-wing populist and right-wing extremist parties, in particular the French Nouvelle Droite and other right-wing parties like the Freedom Party in Austria, where you see that these French Nouvelle Droite philosophers give up the idea of a biological determined social behavior, the inequality of groups by constructing a racial hierarchy, and replace it through the concept of cultural difference, whereas culture is again to be seen as an essentialized natural phenomenon, so that you have a categorical distinction between friends belonging to the same cultures and enemies belonging to other cultures. And racial hierarchies are replaced by the concept of pluralism. So pluralism is again not pluralism, but Alain de Benoit, who is the main author of these conceptualizations, defines pluralism as, again, essentialization of groups, so that groups are a cultural phenomenon which can be traced back to ancient antiquity, and the Jews are always used as an example of such a natural conceptualization. of groups which do not have necessarily to be in opposition to each other as friends and enemies, but what both classic and neo-racism have in common is mixophobia. You are not allowed to mix. As soon as you start to mix, the people, the purity of the people, of the group, of the ethnic group, will be denigrated, so that the survival of the group will no longer be possible. So the structural elements, in my eyes, from a comparative perspective here of the history of ideologies, are exclusivism against mixophobia, essentialism and naturalization of territory and culture, and identity formation based on the concept of sovereignty. Identity is one-dimensional. You have only one single personal identity, nothing else, and you have, or you owe the loyalty to your nation. This is this concept of collective identity formation according to these ideologies. So, again, as mentioned before, is there no way in between Scylla and Charybdis? And this is, of course, now my effort to come to an end, slowly to an end, to also leave more time for discussion. So, we have a continuum of non-recognition of cultural diversities, with here the classic extreme poles, assimilation on the one hand and all forms of separation on the other hand, and what is in between as a functional prerequisite, a functional precondition, is the recognition of cultural diversity, the constitutionalization of the concept of cultural diversity through the notions of autonomy plus integration as the two basic functional pillars, functional structural pillars for the reconceptualization of the legal principles, constitutional principles, be it the French or the German model. So on a very highly abstract level, what is therefore the basic flaw of Europe, of all forms of European minority protection models? First, the conflation of diversity as if this was, as if this were an antagonism between A and B and nothing else. Secondly, the conflation of culture with ethnicity. Again, what is the meaning of ethnicity in difference to culture? We did not discuss that so far. I will come back to that in a moment. And finally, what I call the illusions you will find in political philosophy, including Habermas, that you can dissolve all these dichotomies on the basis of a continuum with more or less thick or thin forms of ethnicity or civility. What makes the difference between an ethnic community and a political community again? I have no clue. I have read almost all the philosophical literature. There is no answer in the end. So all the authors who argue for a political community in contrast to the ethnic community will say, but in the end we need some sort of solidarity. And this solidarity cannot be provided by the state and the institutions of the state. They must come from somewhere else. And what is it? Where does it come from? Of course, from language, they argue. You need a common language in the end. So this is what I call the general problem of the Böckenförde paradoxon. I can explain that, of course, further on in the discussion, which has not been yet resolved in philosophical political literature. So, to come to an end, in the end, we have three meanings, different meanings of ethnicity, be it in legal discourse, sociological discourse, anthropological discourse, and political sciences. we still have primordialist theories in combination with the twin ideologies of racism and ethno-nationalism, which claim that we all have to believe in the common descent or a homogeneous culture as the foundational element for all forms of living together in peace and maybe also harmony. And secondly, what I call here the constructivist instrumentalist position, which is Foucault, Bourdieu, and so on, but also Marxism. And this was mentioned also this morning in the Indian context, the idea that ethnicity, nation, or people is simply a fictitious concept. And like Marx gave the prognosis that socioeconomic classes will wither away with the establishment of socialism and communism, you always also find the position, which I call here the constructivist instrumentalist position, that ethnicity is simply a fiction, doesn't exist. People wrongly believe in ethnicity as people did believe in witches 200 years ago, and burned women because of their red hair, as witches. So give up these wrong fictions and immediately we will start to live in peace and harmony. This is the second theoretical approach, as far as I can see, with regard to the meaning of ethnicity. And I have no idea whether this was also the Marxist background for the Indian development. And finally, what I call here from my own personal experience in Bosnia-Herzegovina, but also in Cyprus, as a legal advisor and judge of the Constitutional Court in Bosnia, is what I would now call a constructivist structural position, that you can have an antagonism on the ground between two or three groups, as you have it in Bosnia, or the two groups in Cyprus, the Turkish and the Greek Cypriots, where all the cleavages, the socio-economic cleavages, the language cleavages overlap and mutually reinforce in each other, so that each and every problem of daily life is seen through an ethnic lens, as this is called. So when you go to Sarajevo and meet your friends in a cafe, and want to tell them a joke, you must first ask, are you a Croat, are you a Bosniak? Otherwise, to be aware that you are not going to insult somebody by your joke. So you can no longer tell jokes on a neutral basis, as liberal ideologists would try to tell us. So this is what I call here the neo-primordial or constructivist structuralist position of ethnicity. And these three types of meanings of ethnicities are constantly confused in public debates, but even in scholarly literature. Finally, almost at the end now, again for the reconceptualization, we have to see 2 minutes? We have to see...
Just because you said almost to the end, so
You see here again, inclusion-exclusion is Janus-faced. Inclusion can also mean ghettoization, or even marginalization by ghettoization. So again, we have to be aware of the fact that inclusion-exclusion is not a simple binary code, but is a double-edged sword. And this brings me therefore to my final graphic representation. If we try to translate, finally, the legal constitutional instruments, I try to give here an overview what is, from a comparative constitutional law perspective in European constitutions, the equality, identity, participation nexus. So you see here, I try to overcome the distinction between individual rights and what I call now group-related rights instead of group rights or collective rights in society and for societal cohesion. And the third pillar is instruments which we find for the representation and participation of minorities in state institutions. And the black colored concepts will tell you what is prohibited, namely direct and indirect discrimination, as well as vote delusion and the exclusion of the right to vote in terms of voting rights for parliamentary representation. What is a new concept I would like to introduce here is the idea of structural discrimination, which is not covered by the prohibition of indirect discrimination, and this basically affects, again, the horizontal dimension of anti-discrimination between private parties, where we started with the case of Ajpita in the beginning, to say, well, housing segregation, educational segregation in the districts of towns cannot be effectively fought against by the concept of indirect discrimination, but nevertheless, there is obviously an unfair, unequal service, public service to different groups of peoples, but you do not have the necessary state action behind. There is no perpetrator who is discriminating. And since you are missing a perpetrator, also the concept of indirect discrimination does not work, because this is then declared societal discrimination, and liberal egalitarians will tell you, that's your problem. Sorry, you live in the wrong part of the town. Just move to another part of the town. And what we know now from, of course, the history of race discrimination in the United States, or with regard to Roma all over Europe, if Roma or like people move into a district of a town, all the whites move out of this part of the town. So this is, again, what I would like to cover with the concept of structural discrimination. And therefore, as the positive side of the coin, you will find in the case law of the European Court of Human Rights, starting with Klimenos versus Greece in 1999, Chapman versus Great Britain, DH versus the Czech Republic from 2007, and Orjuš versus Croatia in 2010, a moving scale of positive obligations or state duties, what I call here the duty to differentiate, a duty to protect the lifestyle of cultural groups, then positive measures, affirmative action measures, and in the end, what we will find in the state institutions is, of course, reserved seats, minimum representation, as this is the case according to the Slovene constitution, with one member of the Hungarian and the Italian community each represented in the Slovene parliament. And in the end, you have proportional representation and power sharing models, as this is laid down in the Dayton Constitution for Bosnia, and was discussed very seriously also for the reunification of Cyprus as a federal entity. So this is, in my eyes, this equality, identity, participation nexus. And the problem is that different types of liberal ideology and different types of nationalist ideology will have a lot of arguments against these instruments. Interestingly, the concept of reverse discrimination has never been brought up in the case law of European courts. So there is no discussion of reverse discrimination, unlike the case law of the US Supreme Court. But again, you can summarize all the arguments against affirmative action to follow up with the comparison maybe with the Indian example or the Asian example, that on the one hand, you will find arguments that affirmative action is privileging the wrong people, the creamy layer problem also in the education in Europe, in particular the United States. Secondly, that affirmative action is ineffective, or maybe even counterproductive. And ineffective means, despite of 30 years of affirmative action for women in Europe, we still have the glass ceiling, and no real progress, in the legal status and socioeconomic status of women. Again, the same is discussed in the US and in Canada, of course, that after more than 50 years of Brown versus Board of Education, 88% of all primary public schools in the US are still segregated. And finally, to take over the phrase Balkanization again, was used by Justice O'Connor of the US Supreme Court in Shaw versus Reno in 1993 in a case with regard to gerrymandering, where she said, no, we need a colorblind constitution, and the concept of a colorblind constitution and racial gerrymandering on behalf of minorities will lead to the Balkanization of the American society. So these are basically the three types of arguments coming from liberal individualistic philosophers and judges and liberal egalitarian positions, basically against affirmative action measures, also in the Western, meaning North American and European context. Thank you so much for your attention.
Thank you, Joseph. And I can say that we had two very thick presentations this morning. And I think that we need to think about them. Listening to them has been a great asset. But then I think that we ought to read them or whatever will be made available. Because there have been many, many suggestions, and I think that now I have to give the floor to Jens Wölk, who will not draw any conclusions, I suppose, but will just try to react to at least a few of the hints and suggestions and the regional ideas and that have been put forward. So Jens, you can take, I think, 15 minutes.
Okay, thank you very much, Roberto. Thank you very much, Joseph and Alexander. I'm feeling a bit like in between Scylla and Charybdis myself now, because I think the most I can do is distract you a bit in order to let it settle what we have just heard and have some first digestion of the concepts we have heard in such a fascinating way by the two speakers, in order to then start with a discussion, if probably there's time for some discussion left. So it's really very difficult because what was the thing with a conceptual disaster area? My notes here are a conceptual disaster area, so I try to go through some things which we have heard, and I apologize also for not having been able to follow yesterday afternoon, so I apologize in advance if there is something which has already been discussed. I tried to inform myself a bit. I think the fascinating, and here probably let's start with something we all agree upon. This is probably something we can all agree upon, that the topic constitutional protection of minorities is raising, as it has been said also in more often, raising practically all issues of constitutionalism and the state. So it's an issue which really goes to the nerve of how a system is framed, how a society is framed, how state institutions are framed. So there's this is why it is so fascinating. It's also clear what we have heard, that we are talking now in 2018, and by contrast with the 1990s or even further back, diversity is much more present. Diversity is considered practically overall a value. I think this is very important. So this is something which has been, I would dare to say, achieved, which does not mean that there are perfect solutions everywhere. On the contrary, we have heard this. But I think this is a different starting point from some decades ago. And this is a great achievement, and there's a great sensitivity for issues regarding diversities, and in many different fields. And this is also a kind of cross-fertilization probably also, because you cannot say, oh, diversity is only good here, without raising the issue why it shouldn't be good also in a different field. And so I think this is an interesting basis, and this seems to me, from what I heard in this workshop, and from which I know, of course, I'm very biased because I'm dealing much more with the European side and only marginally with other parts of the world, in particular Asia. So this seems to me also a kind of common denominator, that diversity is seen as a value, is seen as something positive, and is in any way much more consolidated due to an evolution compared to decades ago in both cases. Now, my task here is also to raise some questions, and I thought that I would like to talk about, with a general question, which is the interest of the conference, whether there are general conceptual and systemic differences between Asia and Europe. So I would like to focus on three issues. One is of the unavoidable issue of definition and the centrality of the state in this definition. The second is related to instruments, and here I'd like to focus will be 3 or 4 sentences, not a thing more. But I'd like to focus on the territorial dimension, because as far as I have understood, this was not so much in the foreground. It has been present, but not so much in the foreground. And the third is the question whether there is something beyond the state, whether there is a kind of, in a way, added value in having an overarching framework, because I think this is, on the face of it, a great difference between Europe and Asia, but maybe I'm wrong. Because, again, I have to say, I'm biased. I felt very comfortably with Josef's presentation in the sense that these are the concepts we all know, and these are the concepts which have influenced a lot. And I felt very, very fascinated, not uncomfortably, but very fascinated by, also due to the kind of presentation which was very efficient, I think, with the pictures in Alexander's presentation. So first, definition. So I think what's clear, for example, I'm a traditionalist. I don't have a problem to call these groups minorities, because I think the issue of number still counts. It's important in the issue of number, of course, also related to the question of domination or subordination, as you said. So I think this is important. But I don't have a problem to say identity groups. There is the pragmatic and very widely quoted sentence or observation by Max von der Stuhl, I know it when I see it. No? So it's rather a theoretical issue and not a practical problem. But what I think very importantly, and this has been said in all presentations, that minority is anyway a relational concept. So you need another group, another one, majority. And here the question is, how is this related to the state? And I was very struck by Jacqueline's concept in the morning, yesterday morning, on the emphasis on divided societies rather than talking on the groups, as you put it. Because on one hand, this is something which actually, and again our topic here, makes legal pluralism necessary. No? If you say there is a division, then this is a serious thing, and you have to take these seriously, or to look how to overcome these. And on the other hand, this is something which probably in Europe is not accepted. I would say it's not accepted. So the divided society is a worst case scenario. So this used to be Northern Ireland, this is Cyprus, this is Bosnia, but these are bad. These do not work. They are dysfunctional. So here again, in my course on minority rights, I always start with a very shortened sentence, which is law is culture. So it's all about culture. And here we have, as Josef was very efficiently telling us in his presentation, we have this cultural bias in our head. This is a kind of uniformity paradigm. And such a thing as a divided society for us is something which, in a way, cannot work, has to be fixed. And sure. In fact, no. And okay, and this is actually the consequence of this ideal of the nation state, of one nation, of the homogeneity paradigm, of the idea, and then of course, but also of the idea of the separation of state and church, and of the idea of the very strong distinction which in a private sphere, where you can do whatever you like, and the public sphere, which is common. I think this is also very, very important here, because this creates then the question, if someone is different, this creates the question of inclusion-exclusion, no? From this common sphere, because you, in a way, you sorted it out, you gave it to the private sphere, these separate and different things, and with language and with the other dominant criteria, which then become markers also for the exercise of power, this does not work. And so here you have to think, fixing with this inclusion and exclusion. And here democracy comes in, because it is about why should we accept majority decisions when we are structurally excluded. No? And so you have to overcome this. This is, but always behind is the idea that there is one sphere, so it's not divided societies. So this was something which struck me, and which I think is very different, or at least different in Asia, because there were, because the state itself is a concept which has been in a way imported, which has been reinterpreted to some extent after the independence of the states in Asia. But the question who owns the state, who's the titular people, is not probably so intimately linked, at least in many of the Asian states, to this question. This is a hypothesis. I remember your example where you said the Malays are actually a minority, or the second largest group only, no? As far as I remember. And then the question of the strong immigrant communities of Chinese and Indians in these states, which have a totally different standing compared to the question, also as Josef pointed out in his last part of the presentation, totally different standing and significance for the whole community and for the state compared to the discussion on the so-called new minorities or migrants here in Europe. And of course, and the other thing I was struck by was this phenomenon of majorities behaving like threatened minorities, which also feeds in here, which is probably a kind of, in a way, insecurity or uncertainty on the from a European perspective regarding of being the titular people of the state. No? So it's not necessarily, as I tried to say before, this kind of rule and exception scheme, but it's something you have to affirm yourself as the dominant political group in such a state. And here, the other question, which I was particularly intrigued by, the question of the socio-economic dimension, which was much more present in the debates and the country studies on Asia. Question of marginalization. My question would be: is marginalization, a synonym for non-domination, or I think it's much more. It's it's not only not being included and subordinate, but it's coming close to physical survival of a minority group, of an identity group. And then the other question, again, always under the question of definitions, but the other 2 points will be much shorter. Another puzzle was the question of the definition in the sense who has the right to define a minority. No? And here I found very intriguing this contrasting approaches, India, China, the bottom-up approach in India, and the Chinese top-down approach. And I'm not, it's just for the sake of exaggerating and for the maybe we can, to some extent, of course, with the cultural bias in our heads, compare this to the question of the ethnic-civic dichotomy to some extent, at least with regard to the dynamics. Okay, then two much shorter points. One was the question of territory and security issues. So in Europe, we have this obsession of the control over territory, because this is how sovereignty actually historically worked and was exercised, the monopoly and the exclusive power of the state. And so in Europe, I would dare to say we have territorial autonomy as an exception. In particular, when it's an exception when it's related to the ethnic divide, to ethnic cleavages. So, and we see this correspondingly, we do not have a recognized right to autonomy for minorities. We have an elaborate framework of instruments on minority protection, but there is no right to autonomy. On the other hand, and this is a nice paradox too, we have an autonomy for subnational entities as a normal feature of territorial government in Europe. Decentralization, regionalization, federalization, we have a lot of tendencies which have even strengthened this over the last decades. But here's in a way a gap. And due to the fact that the EU has much resolved the security issue, although looking at the Catalan case, I'm not so sure anymore. But this was actually what we always thought, that the EU would have resolved through the integration of the security issue, territorial autonomy, but even secession could be manageable. So the security issue was resolved. In Asia, I do not have a very clear picture, because on one hand, there was this positive example which Domenico Almirante pointed out very clearly of the question, and also you referred to it, on the question of the formation of new states in India, again, bottom up. And on the other hand, we have Myanmar, the Philippines, where it again seems rather a top-down process, and but all have in common that there is some ethnic linguistic component in this, and ethnic federalism. This would be very interesting to hear something about this from your point of view. Ethnic federalism, ethnic autonomy. Is this the rule in Asia, and is although from with different approaches, or compared to Europe, where we have an exception, or is this just a relatively new phenomenon? For example, in Myanmar and the Philippines is also quite recent, so maybe it's also still too early to give a judgment on this. And then contrasting with this again, the question of deterritorialization, this is difficult, the role of the internet, social media, which you mentioned, which in a way, and also the urbanization, the mega cities, I think this is also very, very interesting and topical, which in Europe is not discussed to the same extent. Of course, there's the discussion on urban and rural divide in some countries when it comes to ethnic conflict, but it's not so present as in Asia. This seemed to me a different nuance. Last point, the question of a common framework, the question of a regional system. So this would be in a way beyond the state. And here, of course, it's common notion that in Europe, the 1990s were the decade of minority protection. Joseph also reminded of the instruments. But I think there's even more, because underlying, and this goes a bit to also Joseph's provocation at the end, there is a kind of fiction of convergence in Europe. So overcoming this, and this is in a way probably, I would call it a fiction, because I don't see it in reality first. And second, it's a fiction because I would agree with Josef's critique. It's an attempt to create a continuum between the civic and the ethnic. And say, oh yes, let's give in a bit both ways and let's meet in the middle somewhere. This is the ideal approach. But I think this is largely the fiction of convergence. On the other hand, it's also clear that there is an emerging constitutional space in Europe. The importance of the judgments of the European courts, the question of European instruments, and here we have in a way a combination between a top-down and a bottom-up approach, because this is not imposed by anyone, but there is even room for differentiated implementation in the single countries, and this goes back to what Alex also emphasized, the need to have a dialogue beyond legal instruments. And here, with this common framework in Europe, I think you create a debate, you create transparency, there's the monitoring aspect, there are advisory technical committees which engage in dialogue with state institutions. And so, in general, I see this positive, although there is maybe still the bias, the underlying bias of the desire for a uniform solution, which is then this fiction of convergence in a way. So this is something we have still to resolve, and which is probably so far the system we have created acceptable because everybody can put in his or her own model. And my question would be to the colleagues working on Asia, whether this is something which is in a way missing. Certainly it's missing objectively because apart from the Asian declaration, we do not have a common framework. But the question is whether this missing element is something which is important, or whether this is not so important because anyway the differences are so strong. But again, as I said, and I was really intrigued by these contrasting approaches between China and India, for example, are striking. So I think I stop here. I think I have managed to fill 15 minutes in order to let it settle a bit for you and maybe to raise some questions which might be hopeful for the discussion. Thank you very much.
Thank you very much, Jens. You did a great job. We have now less than 30 minutes, and I would like to reserve 5 minutes each to the two speakers, if you don't mind, and of course, if you agree. And for the rest, so we have 20 minutes to share. So who wants to follow up the first discussant? There is a microphone. Yes, okay. Who else? Okay.
So I think I should first say that it's probably a mark of a great conference when at the end of the conference, you end up with more questions than answers. So I wanted to, at this juncture, thank Roberto for putting this amazing program together. So I have many questions, but I'll try to be brief. If you will allow me. One question really goes to the question about the issue of definition. It seems that what is happening, and I wondered if we could connect what you, Alex, talked about, which I see as strategic appropriation of identity that's happening in India. And I think this also happens in other countries, where if you allow certain privileges to be given to certain ethnic groups, then you will see scenarios whereby there is this strategic appropriation of certain identity. And let me just give a very quick example from Singapore. If you recall, I mentioned that we now have this idea of reserve elections for certain groups. In 2017, we elected, without contest, a female Malay president. Now, during the campaign season, this question of whether she is a Malay became really controversial because her father was an ethnic Indian, but he was an ethnic Indian, but Indian Muslim. her mother was Malay Muslim. So the question becomes, is she a Malay? Because her father, in the past, you would follow your father's lineage. So her identity card actually said she was Indian Muslim. But she ran as a Malay candidate, and she obtained a certificate certifying that she's a Malay candidate. So you see there's strategic appropriation at the highest level with state backing. I just wanted to see how that connects to your conceptions about ethnicity, whether the strategic appropriation is something that we should actually celebrate. Because if you can strategically appropriate ethnicity, then there's no sort of fixed idea about, or rather it makes ethnicity more fluid. So that's one question. My second question is this issue that's come up, which is the majority acting as the threatened majority, right? And you raised this as well, Joseph, when you talked about having to protect the language, the majority language. It seems to me that what is happening is fear of a loss of privilege. And I'm not sure if we have a way of dealing with this loss of privilege. And perhaps you could allow me a very, very quick anecdote. My husband is a German citizen of German descent. When my children, my daughter was born, we went to the German embassy in Singapore to obtain a passport. We went there. It was brilliant. I know German bureaucracy is a nightmare, and they made us, jump through several hoops. But the lady told us, "Don't worry. You have to go through all of these bureaucratic procedures, but don't worry. Your daughter is a German citizen. There's no doubt about it. She is a German." She's born to a German of German descent. She is a German citizen. Now, that kind of sort of privilege, that kind of in-crowd, you're an in-group privilege, makes you feel good about it because you have no way of being excluded because they accept you right from the start. And I contrast this. So I'm Malaysian citizen. I go to a Malaysian embassy to get my children a passport. The Malaysians say, "No, we can't do it. They were not born in Malaysia." That's it. And, so for me, if I lose Malaysian citizenship, yeah, whatever. But, okay, maybe not whatever. But, when you don't have that privilege that comes with being in an in-crowd, in-group, then perhaps you feel less worried about losing privileges because you have no privilege to lose, right? But the majority has privileges. And when you have these minorities coming in, that fear of loss becomes really important. And so I'm just wondering, how can that fear actually be dealt with? Because it's completely irrational. What is the role of law? Or maybe law doesn't have any role in trying to deal with irrational fears such as this. So 2 questions.
Thank you. It's over there. Let me just occupy the time by saying that you praised the efficiency of the Italian embassy. And that's incredible for Italians. So,
Thank you, you both for a very brilliant presentation. I have 2 short questions for Professor Marco. One concern the question you posed at the beginning of your presentation. You said, should a minority protect under the framework of the nation state? Do you think a constitution of, or if you like, a constitutional patriotism, as Habermas used to call it, can play an important role on it, or it's just an empty container? By the way, why during your presentation you almost never mentioned the word constitution? Did you do that on purpose? Or the second question regarding one specific aspect of the French model of nation building, which is the principle of laïcité, of secularism. Your presentation reminds me what Louis Favreau told me when I first met him in Aix-en-Provence. He said that in France we have a problem, that we have a religious conception of laïcité, which is an oxymoron, and this has not only affect the conception of sovereignty in French, but also the building process of the integration process of the European Union. What do you think about that? Thank you.
Other questions, other comments? May I just add that Louis Favoreux was a member of a minority himself, or he was an Occitan. Anybody else? Then I'll make a remark, and that may be a question if you like. I'll try to make it very short. I think that starting from the three Europes that Joseph has described, that map was very useful. Nation state, small state-like political entities, and multinational states on the east. And may I just add that the Soviet Union was also a continuation of the multinational Tsarist regime. It seems to me that in Europe there has been a clear determination, a clear ideological determination to build up a nation state according to some ideological features, which may be united under the name of uniformity, one language, one people, one nation, and whatever. I wonder if the same kind of determination has been integral part of the constitutional design in Asia. And I say this because on the one hand, I suppose there has been some influence of the colonial powers, in particular the UK, I would say, perhaps not so much France in Vietnam, or I don't think that those countries under former French colonization have felt that influence as much as the countries that have been under the British rule. So I wonder if in Asia there has been such a well-built ideological frame of reference for state building through nation building. Of course, you have to work with the tools that you have. And it was easier, perhaps, in Europe to rely on ideological foundations that have been elaborated over a very long period of time. We shouldn't forget that a national monarchy started in the UK, in the 12th century, and also Spain and also France and Portugal to a lesser extent had a period of centuries, and they were able to achieve national unification at the same time in which they were using absolute powers. So there has been a coincidence of the nation building with the enjoyment of absolute powers, which explains, for instance, the domination of national languages. So perhaps the history in Asia and also the time constraint, the time period, has been quite different. And I wonder if that may be worthy of some consideration. Anything else? So shall we give the word? We give the floor back to Alexander. Is that all right? So you have more? No, you have 5 minutes. And you also want to leave more room to Joseph. Okay? Not so much. No.
So 2018, where do we stand with the diversity and identity politics? I still remember, I essentially, when I went to university, most of my mentors were pluralists, right? We once had Pierre Legrand at SOAS, and he said, when I was studying comparative law, everybody was a positivist. Yeah? Whereas at LSE, there was Simon Roberts, who, in a way, thought not unwell of legal pluralism. Then I worked with Professor Mensky, so Diversity, identity politics, politics of recognition. We've now seen it for almost 20 years. Yeah. But so the point you raised, where do we stand? How do we assess? Where has it taken us? Pitfalls. Yeah, is the identity politics we see of the neo-right sort of a backlash to the identity politics, or to what type of identity politics? I mean, I sometimes try to distinguish here between the value of diversity and specific types of identity politics. And in that sense, India is a very, the ability of the Indian state and Indian judges to defend constitutional morality and to intervene into identity politics in quite an aggressive way has been there for a long time as well. And it's particularly true in relation to untouchability as a form of caste discrimination, for which there is no tolerance whatsoever in the Indian constitution. It's becoming slowly, but step by step, quite prominent in relation to gender discrimination. There's a big case which you can watch out on temple entry for women. There have already been 2 decisions pro temple entry for women. The 3rd one is going to come very soon, I think. So that intervention, not upholding a value like you inherit your identity from your father, that has been there in the last 30 years. Yeah? Also all rules of caste endogamy and patriarchy in terms of identifying people in an intermarriage, they've all gone out of the window. It's now objective criteria or a question of choice. Yeah? You can say which group you belong to. So if you applied Indian law to your case, it's a Singapore, yeah. You would say it's her choice. She can pick and choose. She can't go back and forth, I think. Yeah. So if she once says I'm Indian, you wouldn't allow her at some point of time to switch back into the Malay category, which raises further interesting questions, I think. Yeah, so that's a general comment on identity politics with the rise of economic inequality. Authors like Chantal Mouffe for Iris Young, about the politicization, also bring the political back into diversity. I think they have a lot more relevance for me than they had in the past. Yeah,
Sorry, that is not a positive contribution to the discussion.
Yeah. Maybe one more point about this strategic appropriation. So the examples from China, India, also Brazil. It's sort of a shame that resources are so scarce that people have to go through this strategic appropriation of switching identities or engaging in a strategic identity politics. So it's almost absurd in India. India has, I think, 20 national law schools. Each of them takes 80 students, so you can imagine the competition. They have 2 million students applying for national law schools almost, and they have a couple of hundred places. So, I mean, that's a context there also in terms of that strategic appropriation. And people do all sorts of crazy things. They get adopted by their servants and claim a caste certificate or claim so diversity unfolding here, maybe in a context of a new type of economic inequality. New for us. In India, a lot of identity politics and diversity politics, I think, is also because there's no choice, right? You don't have a choice to join a union, which is really powerful. You don't have a choice to, so non-identity forms of political organization are not that strong, maybe. Yeah? I mean, it's something I would need to think about, but I think it might be another factor. Yeah? So that identity politics, when it becomes the only form of politics, that might lead down the wrong track indeed then. I think I've I've got some other notes, but it's a bit wild. So, intra-minority reform is very strong. Yeah, maybe if I could come back after you have given a long response.
Well, I start in the order of the questions to address first the two questions raised by Jacqueline. The identity question and strategic appropriation and identity definition question is very much familiar also in Europe. And there is a decade-old or even century-old discussion when you look back into the case law of the imperial court of the Habsburg Empire. What is the correct way to define identity? Can you give an objective definition, or is it a matter of subjective self-definition? So this is the old dichotomy going on for more than 100 years. And as far as I can see, after 100 years, there is no solution to the problem coming from the case law. So, for instance, the Austrian Constitutional Court finally said, well, any effort to objectively define identity on the basis of mother tongue is not objective in the end. How do you then define mother tongue? In particular, when children are raised bilingual, maybe. So the way out, the Austrian Constitutional Court found with regard to the Slovene speakers in Carinthia who have a constitutionally guaranteed right to use the Slovene minority language as an official language in the traditionally inhabited areas of the Slovene minority in Austria. It's to say, well, it's impossible to find a solution on the basis of mother tongue or self-declaration, self-identification. So we simply stick to the territory. Everybody who wants to speak Slovene in this territory has a right to speak Slovene in this territory. So it's again, the way out was the territorial solution, and and Jens immediately reminded me, of course, also of the Bosnian problem with regard to strategic appropriation. Who is a Croat? Who is going to define who is the Croat having a right to stand as a candidate in the elections for the presidency, the three-member presidency of the Bosnian state? And unfortunately for the dominating Croat party, the wrong Croat had been elected. So it was not a member of the political party, the HDZ, who ran as a candidate, but from a second, different party, with the support of voters from the Bosniak electorate, became elected as a Croat member of the presidency of the state. So you have a huge discussion on the very day. How can you avoid that the wrong Croat will be elected as a member of presidency? So they really want to change the constitution now. And this brings me back to the question, what we discuss here in Europe in terms of power sharing instruments is, of course, the question of corporate power sharing, so that you have, like in the Bosnian case, already fixed in the constitution itself, one Croat, one Serb, one Bosniak shall be a member of the presidency, or does this lead to further ethnification and division of society? Do you cement division by such a system of corporate power sharing? Or can you start a process of de-ethnification of the institutional system by transforming the institutional mechanisms, in particular at state level, to liberal power sharing model as this is in place in Northern Ireland? So that you do not have, by definition, fixed one Croat, one Serb, one Bosniak, but that you leave it again to the self-definition, and of course the electoral support, in the elections, who will win in the end the position of the president to be accepted by the electorate as the true Croat, true Serb, or true Muslim Bosniak. So this is the question, and of course there is a lot of misuse. For instance, in the Romanian system, with reserved seats for minorities in Romania, where all of a sudden people find out, well, this is a very lucrative job, to be a minority representative. They found a party and say, I'm a member of a minority who was never known before, and he gets enough votes to be elected as a member of the parliament. So this is again a lucrative job, so minority representation.
14 reserved seats.
Yes,
in Romania.
14.
Incredible. Very high.
So second, ethno business, Second, your question with regard to threatened majorities, I have absolutely no idea how to solve this problem. This is exactly the same problem in Europe, all over Europe, and it has to do with, in my opinion, with what I called the dilemma of difference, because we have some sort of an inherent belief that what is normal shall be the norm. And this is exactly what Martamino describes as the epistemological or cognitive problem of a dilemma of difference. And this is also the dilemma for affirmative action, by the way, which she describes very elegantly in her book. And she gives an example which really fits to me because I'm hearing impaired, and she makes the example. What is the norm? The non-hearing impaired person or the hearing impaired person? So if you give in this respect, well, recognize the disability, this is maybe a favor, but it can be at the same time also a stigmatization. So this is the cognitive problem of the dilemma of difference, and how to avoid this cognitive problem of this dilemma of difference through affirmative action is, again, an unresolved problem. And my last response with regard to constitutional patriotism simply disaggregate constitutionalism and patriotism. Patriotism is the positive side of nationalism, is it? First question, counter question, And secondly, what is constitutional patriotism? I know what Dolf Sternberger, who invented the concept of constitutional patriotism means, and Habermas then went on to develop this concept. Of course, the background is again with Habermas that he sticks to the idea that you have some sort of intellectual horizon of necessary common intellectual horizon of understanding for his theory of communicative action. And again, this is the trap. As long as you stick to the necessity of a common horizon of understanding, which he has taken over again from Gadamer, this concept, you will end up that intercultural communication is not possible. If you require this common horizon of understanding. So I do not think that constitutional patriotism in his writings, he again refers to language and says, well, we need a common language. There is no communication with language, and he does not go into the problems of translation from one language to the other and the other way around. So in this sense, I think constitutional patriotism is again, or remains trapped in this thick, thin categorization and the continuum, and cannot give a final solution. And this brings me also to your question with regard to Louis Favreux and the French model of laïcité, and Roberto's intervention in one final sentence. Maybe, yes, I think that we have again a wrong opposition in place with regard to secularism. On the one hand, so that we think that secularism is basically following along the lines of the French model, a strict separation of legal authority on the one hand, and religion on the other hand, removing all religious discourse from the public space. I think this is not a basis for further European integration. And secondly, of course, a church-state model, a monopoly of one church in one state, as you have it in Greece, for instance, in the constitution of Greece, as the exact opposite model is not possible. Also in Europe, and not possible for further European integration. Therefore, I would like to propose a different model, which I would call religious pluralism, the model of religious pluralism and culture, so that we retranslate the individual conceptualization of Article 9 with regard to positive and negative freedom of religion. Also, when we look into the case law of the European Court of Human Rights with regard to the headscarf issues and the burqa bans, you will see that the European Court of Human Rights has two different models in place to solve the individual cases. On the one hand, the court upholds all the banning of religious symbols. The case Dogru and Aktash versus France and SAS versus France is what I would now call the negative equality model. So again, the religious indifference, neutrality is defined as long as you prohibit all manifestation, public manifestation of religious symbols, you are neutral. Equal vis-a-vis. This is what I would like to call negative equality approach. And in Leyla Şahin versus Turkey, you have exactly the opposite model, where the court rules out it is necessary for the state institutions, this is even an obligation, to bring conflicting groups together and to ensure tolerance among them. So this is the pluralist model, which I would coin positive equality, the positive equality approach. And there is absolutely no final solution in the case law to be seen where the court will go into the future. But I think this positive equality approach, which has very much to do with what we heard yesterday about secularism in India, is very, in my opinion, very similar. So why not only have a cross here on the wall, but maybe also a figure of Buddha in the background. So what's wrong with this in a classroom? So this would be the positive equality pluralistic approach. Thank you.
Okay, thank you very much to Joseph, to Alexander for the presentation this morning and for the final remarks. I'm sort of relieved because we are in a hurry. And so I won't even try to draw any concluding and final remark. And I'm sure that you will feel as relieved as I am, because we also want to quit. Now, this was supposed to be a workshop. I would say it has been an inspiring dialogue. So I'm very grateful to all the speakers who accepted to come and to contribute. The goals were ambitious, but the outcome, I would say, is even more ambitious. I would like to thank the staff that have assisted us so much. And in the end, I hope you will allow me to praise the students who have been here until the very last moment. I'm quite surprised. And of course, it is a nice surprise. So, and I hope that you feel that you gained from participating until the very last moment to the conference. So the conference is over, the workshop is over. Thank you very much. Have a nice weekend, and I hope the weather will assist you. Thank you. Al Rosa d'Oro.
Can I ask you?
Assolutamente.